Good morning, everyone, and welcome to today's training, Educational Surrogate Parent, presented by Shirley Swope. My name is Pam Christie. I'm the PTI director here at Peak, and I will be monitoring the chat through the training. Before we get started, I'd like to go over a few items so you know how to participate in today's event. You will be muted for most of the presentation. Since I am recording this session, I will also be closed captioning it and adding it to the website. I will unmute at the end for questions and answers, and you're welcome to use the chat to ask questions. Handouts and the PowerPoint were emailed to you yesterday. And as you leave today's webinar, you'll receive an evaluation survey about the presentation. We would appreciate if you would take a few minutes to complete that and provide your feedback. We're always looking to make improvements to Peak services. It is my pleasure to introduce Shirley, who will take it from here.
Well, welcome today, and welcome to the Educational Surrogate Parent Training, or ESP training. We are presenting this with the cooperation of the Colorado Department of Education. And thank you. Why did you think about, why did you become interested in becoming a surrogate parent? It doesn't mean, and do you even know what that means? It's kind of an odd term. And, but we'll be talking about this today, and what kind of information do you need to fulfill this role? And we'll just kind of move on. This training does last till noon today. What is an educational surrogate parent? An educational surrogate parent is someone who acts in the role of parent at a student's IEP meeting and IEP participation. It's more than just the meeting, it's the participation in school, and acting as any parent would act with their child in school to a degree. You are not responsible for any educational materials. You are not responsible for any physical care. You're not responsible for any kind of care that a parent or a foster parent would provide for a child. You are responsible to make sure that the rights of the student are respected and observed during the IEP process, the meeting, but also implementation of the IEP, starting with evaluations in many cases. So under the Individuals with Disabilities Education Act, each school district must ensure the rights of each student are protected. And because the law states that parents are an equal member of the IEP team, when a student doesn't have a parent who can participate in this role, and it's when no parent can be identified, or the parent can't be located, or the parent is a ward of the state, or the child is an unaccompanied homeless youth. If you have parents who are incarcerated, it does not mean the incarceration takes away your parental rights. It doesn't. It could be that parental rights are taken away if a parent's incarcerated, but not necessarily. So even if a parent is in prison or jail, if we know where they are, they can participate if their parental rights have not been terminated. If their parental rights have been terminated, even though we know where they are, they no longer have that right to participate in the IEP process. Sometimes parents drop off kids with grandma who is overwhelmed, and grandma doesn't know where the parent is, but she's acting in the role of parent. Sometimes grandparents just take off and can assume that role. Other times they choose not to. Sometimes parents are working on reunification through the foster care system. We know where the parent is, but that parent, because of court orders, does not have parental rights at that time or educational rights. So it could be that that be the case, the educational surrogate parent, or ESP, would be asked to participate in this whole process. When a student is an ward of the state, it means that parental rights have been terminated, and the state is now in charge of that child's well-being. The child might live in a foster home, or a child might live in a residential home, or the child might be incarcerated in youth incarceration. A child with an unaccompanied homeless youth, we have quite a few of those children, old teenagers, teenagers who either have been kicked out of their homes, their parents no longer want them to reside with them for, various reasons, and or the youth does not know where the parent is now. The parent has kind of disappeared from their home, or the youth has run away. So all of these situations are trauma situations. So being an ESP for a student, they didn't get there on an easy road. This is a hard road, and they're there because of some trauma that's happened in their life. So in our state, in all states, to be an educational surrogate parent, you must be an adult, at least 18 years of age, and be a resident of Colorado. You can't be a surrogate educational parent for students in Utah, Wyoming. You have to live here. You have to have, there can't be a conflict of interest with the student. And that means, like if you're the student's teacher, you can't be the ESP for that student, because that would be a conflict of interest. You're being paid by the school district. And there are parents who have students who have IEPs and the parent works in the school. That's different if you're a birth parent. But in this case, it's a voluntary service that you're providing to the school district and to the student. And you can't be paid on the outside to care for this student through another facility. So the student's caseworker probably could not be an ESP. Not an employee of the Department of Education or the Board of Cooperative Educational Services. You can be a teacher getting paid by one district, and then you can act as an ESP in another school district, but not in your school district, because that would be a conflict of interest. Parents are not required to know about the education process. They assume that they're going to learn, and the school will teach them how to, what that process looks like, and encourage them to kind of gain information on the outside. In this case, you are required to have a basic knowledge of the IEP process and special education law as it applies to the IEP. Training is, the school districts are responsible to train volunteers, and the Board of Cooperative Educational Services, they have this responsibility to train volunteers in this ESP role. Colorado Department of Ed, and with the consent of the school districts and the Board of Cooperative Educational Services, ask Peak Parent Center to do that training for the state. Since Peak is the parent training and information center for the state of Colorado, every state has at least one PTI, or parent training and information center. And one of our responsibilities is to educate parents around the special education process and the IEP process, and provide resources, information about resources in the community. So that's why Peak Parent Center has agreed to do the educational surrogate parent trainings. And the ESPs need to kind of keep on top of their training year to year if they, choose to do this role. ESPs are volunteers. You do not get paid for this. And you're placed on a list through the Colorado Department of Education. That's why we need your contact information, phone number, and email information. And Pam will request that in the evaluation that comes at the end of the training. So please provide that to Pam so she can provide that to Marianne Fleury, who is the coordinator at the Colorado Department of Education, about ESP trainings. And you may be contacted at any time and requested to serve as an ESP for a student. And obviously, school districts will have students who all of a sudden show up, maybe living with a family in a foster care situation, or they have residential treatment within their district. And all of a sudden they get a student that needs this service. So the assignments are made by the special ed director of the school district or the BOCES, or by court order. So sometimes courts will order a certain person to become the educational surrogate parent, and court orders supersede education law. So the judge may order the guardian ad litem to be the educational surrogate parent, or another person that might be appointed. Or the judge may say parental rights right now are kind of on hold or terminated, and the student needs somebody to intervene educationally for him. So you can, the judge can decide the student may still be living at home, but the judge decides that somebody else is going to be in charge of the educational decisions, then an ESP would be in place. And school districts or BOCES must submit the assignment of an educational surrogate parent to the Colorado Department of Education, and they keep track of that. So if parental rights have been terminated by the courts, or the courts have revoked a parent's educational decision-making authority, and sometimes with really contentious divorces, that might happen when parents just keep using the child as a pawn, and one parent will ask for a service, another parent denies it, and it's going back and forth like that. If they're using a child as a pawn, courts may come in and say, no, both of you can't make educational decisions anymore. I'm going to let somebody else do it. Or the student's parents or guardians are unknown or can't be located. Or if the student has a guardian ad litem, but the court orders do not include that responsibility. So many times guardian ad litems don't want to be the educational surrogate parent because they don't know or they don't feel comfortable with special education laws. And if the student has been determined homeless, the big cities, Denver, Colorado Springs, Pueblo, they have homeless shelters for youth. And you can be homeless, but if you're homeless with your parents, they don't need an ESP. Being homeless is not something that would take away your parental rights. It's a circumstance of life, and there's a law that kind of helps protect homeless youth, and but it does not interfere with the parental rights of people. So and that law is the McKinney-Vento Act. And that law states that if a student becomes homeless, they can remain in their school that they were attending and get transportation to and from that school from wherever they happen to be. And they're still considered part of that district. And there's some other rights that they have under that too. So the district has, their responsibility is to recruit and maintain a list of trained ESPs in their school district. That's why it's important that we have your contact information, and they try to assign ESPs as close as possible to the student, where the student is residing at the time. If a student is determined to have that need of an educational surrogate parent, the district has 30 days to assign somebody to that student, and then submit that official written ESP assignment to the Colorado Department of Education. And to ensure that every ESP is assigned to a student and that person has the knowledge about how special education works and what those students' rights are. And then the district is to invite the ESP, as they would invite a parent, to participate in special education process in the same way any parent would participate, and provide an opportunity to become acquainted with the student. This is a really important concept. If you're a birth parent, you are acquainted with your student, you live with them. But in this case, this person is going to be a stranger to you. And so they have to provide a chance for you to meet and to speak with and to kind of get to know this person that you're going to represent as a parent at the IEP meetings. And it will be kind of your responsibility too, to share that with the student, this whole process, because these students aren't going to, know that, well, who are you? You're this person coming in and just more trauma or what? So it's a chance to get to know some special people that you would not otherwise meet. And it starts, a surrogate educational parent can be requested birth to 21 years old. So if for the Pam and I both have acted in this role as a surrogate educational parent. Pam, do you want to just mention your experience?
Yes, I'd be happy to. So I'm in Elbert County, which is a fairly rural area. And I have been, my most recent was a few years ago. It was a baby that was in foster care. So he had an IFSP. I'm very familiar with that. My daughter lives with cerebral palsy and was also on IFSP. So I was with that baby for a year. It was a wonderful experience. I went, luckily the home where this baby was being fostered at was about 15 minutes from my house. So I was able to see the baby in person and some of the therapies that he was receiving. Since I was acting as his parent, I felt that was really important. The foster parent ended up adopting him. So that's why it only lasted 1 year, but it was a wonderful experience. I really enjoyed it. So that's the experience I wanted to share, Shirley. Thank you.
IFSP is Individualized Family Service Plan, and it's for children birth to 3 years old. And at 3 years old, that plan would switch to an individualized education program. I was a I was a ESP for a few kids. A young man, my first one was a young man who had very significant cerebral palsy, and parents had relinquished their rights to him because they felt they couldn't, well, mom felt she couldn't um, care for him properly or safely. He was relinquished to the state, and he was 14 at the time and lived in an institution. And that was my first experience. And he was a very happy and loving, person. Just, it was a sad situation. The other one I've had was another IFSP, or a little kid, and he was 2 or 18 months when parental rights were terminated because of drug use in mom. And and then he went to a foster home. They were going to foster adopt, and foster parents can act as parents, but they just received him. He was brand new to them too, and brand new to this whole process. And they did not feel comfortable acting as the educational surrogate parent for him at that time. So at that time too, they needed someone to sign a form that allowed evaluations of this little guy. And so my role as a surrogate parent started at that point. He did not have an IFSP. He just came into the foster care system. So it was my responsibility to give permission for evaluation as a parent. And so your role can start then. Some of these kids, when they come into foster care or come into the system, are not evaluated or haven't been evaluated. And so that evaluation, they need a parent signature to start that evaluation. Another time I was the SP for a teen girl who was incarcerated. And this that in the, so she just moved to the juvie jail, and they were looking to see if she was going to qualify for special education services. So as a parent, ESP, I was called in to meet her and to get to know her and talk with her, and then signed the form for evaluation to see if she qualified for special education. She did not, so my role was over then. But it was really evident that even though her life was pretty traumatic and she made some really poor decisions, she was she did not qualify. And so you have this difference between emotional disability and socially maladjusted. And she was socially maladjusted, but she did not have an emotional disability. So it's interesting, people that you get to meet. And I hope her life turned out okay. And she probably has, she had a chance to kind of turn things around. So your rights and responsibilities too are to participate in like these, training sessions and follow-up sessions. And you are to only serve for students that are assigned to you. You can't just, the school district can't say, you're doing a great job being ESP. Do you want to just kind of look at this kid over here and pop in and, see if you can, be an ESP for him too. Only for the students you're assigned. Just like your own student, your own child, you can express an opinion about that, but not other students who are not assigned to you at the time. Procedural safeguards with respect to identification, evaluation, placement, and provision of free appropriate public education. As any parent who is in this IEP process, you do have that right to participate in the identification of a student who might have a disability as a parent would, but they need your signature. That's when you would, they may say, you need to come and, would you come and sign to give us permission for evaluation. That's part of that identification. The evaluation process, they're going to share with you the evaluation results, just as they would share with you the results of your own child if your child has been evaluated. And then you participate in that IEP planning session that talks about where are these services going to be provided for the student, the placement, what kind of services are needed and who's going to do it and where's it going to, kind of happen. And is that appropriate for this student? Then that provision of a free, appropriate public education. Are they really looking at providing services? First, the place you start is the classroom that child would attend if that child did not have a disability. Adding supplementary aids and services to that setting. That's providing FAPE. To participate in the special ed process, those meetings, those IEP meetings, but also getting to know the kid. And if the school has a school newspaper or school, letter or news thing that they send to parents, they're to send it to you. You're to get any information that any other parent would get. If you get to look at report cards, you get to look at disciplinary, incident reports, you get all of that. So you're participating as a parent in this child's education. So it's not just one meeting, it's this continuous contact that a parent would have with the school. You get to go to the teacher meetings to see how the student's doing. You're also to comply with confidentiality laws. So when it's your birth child, you can talk about your birth child any way you want to anybody you want to. When it's your surrogate child, you have to respect his rights to confidentiality. So you don't discuss the student with your mom, you don't discuss the student with people in the grocery store. It's confidential, and you need to respect that confidentiality. When it's your own birth child, you can say whatever you want, but with this child, you practice confidentiality with this child. To grant or deny permission for the assessment, that's really important, or placement. So that's within the IEP process. And you have the right to initiate dispute resolution options. If you feel like, you guys can do a better job than this, or I don't agree with something, you have the right to mediation, you have the right to due process, you have the right to a state complaint. Even though you are appointed by the special ed director of that student's district, you still have the right to due process. And due process is the umbrella that covers mediation, state complaint, and a due process hearing. You're to act in good faith on behalf of the student in protecting his rights. So even though you're appointed by the district, they're not paying you. This is a volunteer position, and you're acting in good faith to protect that student's rights. So if those rights are being violated, or if those rights are not being, the plan is not being fulfilled as you thought it should be, you have that right to speak up about that. And the special ed director cannot replace you. They can't say, I don't like how you're kind of fighting against us, so we want somebody else to come in and act in that role. They have to also act in good faith. And as a parent, you have that right. And as long as this, what's the length of the assignment? As long as you want, basically. The student is going to need an ESP until the student graduates or no longer eligible for receiving educational services. And in our state, that's 21 years old, the semester after a student turns 21. If you have a student if you graduates with a general education diploma, services stop then. Some students require transition services, so they would have services after 18 to 21 years old. If they have an IEP that requires that, you can still be involved in that. Or until the legal guardian is able to fulfill the responsibilities. And that could be when, like Pam's situation in foster adopt, then the foster parents took over the role as parent until the parents are located, or the special ed director may determine that the ESP is not adequately representing the student and may terminate the assignment. If you don't show up, if you don't participate in good faith, if you don't take the opportunity to meet the student and to get to know them, then the special ed director can kind of terminate your voluntary assignment. However, he cannot if you have been participating in good faith, you have been meeting the student, you have been talking to the school, and you ask for mediation. He can't turn around and say, no, we want somebody else. So or until you resign. If you win the lottery and move to Hawaii and you want to go, congratulations and have a good, life. Just let us know 15 days in advance so another person can be appointed to that position. Or if you feel it's too overwhelming, I can't do this now because other things going on in my life, 15 days notice is requested. So when you are assigned a student, then that is suspected of having an educational disability. You can have a disability and if it doesn't interfere to a significant degree your ability to learn in the classroom, you're not going to have an IEP. Same with these children too. But that's when you could start with that evaluation process. And if the student is, something's going on, but he only needs IEP, and he doesn't need an IEP, but maybe a 504 plan, then your job is done at that point too. So it's through the Individuals with Disabilities Education Act that this requirement comes. And the IDEA is the federal special education law. The Exceptional Children's Education Act is Colorado's special education law, which is in compliance of the federal law. All state laws have to be, this educational state law has to be in compliance with the federal law. So Section 504 is a federal law. It is not an education law. It does not require exceptional educational surrogate parents. So if you have a 504 plan, you would not that child would not qualify for an ESP, only if the disability is such that he requires an IEP, Individualized Education Program, or Individualized Family Service Plan for the little guys. There are 14 categories under which you can qualify under the federal law. And the federal law also dictates these procedural protections for students. Those are the procedural safeguards, parents' rights and procedural safeguards. And at the Colorado Department of Education, under special education, the unit, which is the Exceptional Children's Education unit, posted you can download your procedural safeguards and parent and student rights handbook. And that's a good thing to kind of read and become familiar with it. Here are the categories under which you can qualify. Autism is its own category. Hearing impairment, including deafness, serious emotional disability. And serious emotional disability is one that is commonly dealt, children because of the trauma of their life to get them to this point. This is a category that they kind of suspect and look at. Serious emotional disability. It might be intellectual disability. The term mental retardation is no longer used federally and or in the state. It's intellectual disability. Multiple disabilities are when you have two disabilities of equal impact on a student, one of which is going to be intellectual disability. You can have an orthopedic impairment and hearing loss. That is not a multiple disability. You have two disabilities, but with multiple disability, one of the disabilities must be intellectual disability in Colorado. Orthopedic impairment, such as cerebral palsy, would fall under that, spina bifida, things like that. Other health impaired, such as a student with, a chronic disease, or ADHD follows under that category. So and that's a fairly common contributor to students not being successful at school is ones that have ADHD, and that's other health impaired. Specific learning disability, that includes dyslexia, dysgraphia, dyscalculia, things like that. So, but with a specific learning disability, your intellect is average or above average. Speech and language development is the most common category for under 5 population of students and children. So, and it can be a standalone. You can have no need for a special education teacher if you have a speech therapist, because if speech and language is your impairment. Traumatic brain injury. And the Brain Injury Alliance of Colorado now has an educational advocate who can help parents kind of maneuver this and give information to them. Visual impairment, including blindness, deaf blindness. Deaf blindness is its own category due to the impact of the two senses being impacted at the same time. Creates its own unique symptoms, I guess you could say. And so deaf blindness has its own, it becomes its own category. Developmental delay is for young children, birth to about 8 years old, before we can, is there something else going on? Why do we have this developmental delay? And at around 8, the developmental delay category changes into another category if need be. So it might develop into learning disability, or it might be reclassified as other health impaired, because what we really are seeing is attention deficit disorder. So developmental delay is kind of this umbrella category for young children before they can actually figure out what's going on with them to cause that developmental delay. Infant toddler with a disability. So you might know right away that a little guy's, born with Down syndrome. That's a real evident one. And then they would qualify as an infant toddler. So, it's really important that you're volunteering for this stranger that you're going to be representing in a role as parent. And you want to look at, you want to think about what's your experience with a person with a disability? How did you first come about knowing somebody with a disability? And how do people interact with people with disabilities? We have a lot of assumptions in the world, and we and that are based on our real life experience. So we just want you to think about those things. And what are things important to consider when you're interacting with someone with a disability that may be new to your whole world experience? So the disability categories are only a way to ensure that the student's eligible for special education. You can have autism and not qualify for an IEP if it does not have a significant impact on your ability to learn. And looking at your academic achievement and your functional performance, and that functional performance is the behavior and social aspect to school interactions. So that functional performance is really important. You can be a straight A student, but if you can't handle, behaviors, if you don't have behaviors that are typical, if you can't handle the stress of being in a big classroom with kids, that functional performance may make you act out in a way that gets you kicked out of school. Then you might qualify because of your functional performance, not your academic achievement. But your behavior is interfering with your ability to learn at school. And this category does not define a student. You can be a student who has a hearing loss, but you also have a learning disability in math. So you're not just going to get services for hearing, you're going to get services also for helping you to learn math. So it doesn't define you. We don't have a classroom just for students with Down syndrome. We don't have a classroom just for students with learning disabilities. Those supports need to be blended into their whole day. You don't have a disability, hang up your disability cloak when you leave the resource room and put it back on when you come into the resource room. You have that learning disability all day long. So if a child has a learning disability in reading, reading is like a blanket that lays over all your subjects, and you have to accommodate that student in reading, in math, in social studies, in PE. You need to talk about how are we going to support the student who has a reading disability, even though they're in 8th grade, they can't read at that level. How are we going to support the student? So the category does not define the student. Services are always about the unique needs of the student, not just, well, this is what we do for kids with hearing loss, this is what we do for kids who are blind. No, it's looking at the unique needs of the student always first. And to remember that people are more alike than different. So kids in school are general education students first. If there's any program in school that is allowed to a general education student, that program is allowed to a student with an IEP. We're more alike than different, and we've got to look at how do we support these students in school so that they can be successful learners within that environment. We always want to recognize and value the person first. Disability is one aspect. And these kids that we're talking about may have a disability that is one aspect, but another aspect that's unique to them is the trauma that they've experienced to get them into a situation that they're required to have an educational surrogate parent. We always use people language first. I have a son with a hearing loss. I don't have a hearing impaired son. So we always want to put the person first, and to remember that the disability that is qualifying them for these services is only one aspect of a very complex person. We all are very complex people, and we need to recognize that and remember that. Think of your own children, think of your own self, how complex you are, and what one word would define you. Do you want to be defined by your deficit, your one deficit, and not defined by your many successes? and many strengths. So we want to focus on making sure we focus on that whole person, not just that disability. So part of the special education terminology is this free, appropriate public education. And that's really important. That's been in the law since 1970. For when it was written and came into being. And that really is making sure that they get an education that is meaningful for them so that they can develop as adults as best they can within the school system. It's free to the parent and it's appropriate for the child. It's not babysitting. And special education and related services are designed to complement general education. It's there so that kids can access the general education curriculum in the least restrictive environment. And these are all words that were in the law from the very beginning. And that least restrictive environment is that children will be educated with children who do not have a disability to the maximum extent appropriate with the use of special education and related services, and that's supplementary aids and services. That's what special education and related services are. They are supplementary aids and services. And special education related services at public expense, in being in conformity with the IEP and in the LRE, the Individualized Education Program, that's executed within the least restrictive environment. And it's going to be reasonably calculated to produce educational benefit. This is an education law. This is not a babysitting law. This is an education law. And we really do expect and we really do want children to be able to learn so that they can support themselves and be successful as adults. And we're going to give them that basic floor of opportunity. We're not giving them anything extra. We're giving them extra only so that they can have that basic floor of opportunity because of the disability that's interfering with their ability to learn. So that's how special education does. It just makes it so that the student can learn and can go on to be an adult because they had that basic floor of opportunity. And often laws are defined by litigation. This is a definition that came about because of this lawsuit at the bottom. And in Raleigh, the Supreme Court established a two-part test to see if a student was getting an appropriate education. One, is the state doing their part? Are they complying with the procedures set forth in IDEA? And this is part of it. And is the IEP developed through the IDEA procedures? And is it reasonably calculated to enable a child to receive educational benefit? And that's where those good evaluations come in too. We need to have a good starting point. And that's why those evaluations are important, because we have to look at where's the child starting before we can know how far we want to set the goal for them to reach within 365 days. That's including academic achievement and functional performance. Under Andrew F. versus Douglas County School District here in Colorado, it was determined that when the U.S. Supreme Court determined that when providing special education services to students with disabilities, school systems cannot simply ensure that the student makes minimal or trivial progress year to year, but instead must ensure that the student make meaningful progress given the student's unique circumstance. Andrew F. is a young man now who has autism. And when he was in Douglas County School District, they were focusing on his behavior and neglecting his academics. It's a two-part prong, academic achievement and functional performance. They were simply looking at functional performance and not academic achievement. Supreme Court came back and said, no, you can't do that. You got to look at both. So IDA requires an educational program to be reasonably calculated to ensure that a child may progress in the light of the child's circumstance. His parents took him out, put him in private school, and he started making academic progress. And parents came back to Douglas County and said, we want you to reimburse us for private school expense because he didn't make any academic progress when he was in your school system. And they said no, and it shot it all the way up to the Supreme Court. Supreme Court came back in favor of the parents, said, no, you can't just look at behavior. You can't just look at one aspect. You have to look at the whole child, and he has a right to academic progress in light of his unique circumstance. And so they were reimbursed. And it must be, the program must be appropriate and ambitious in the light of the student's circumstance. And just as advancement from grade to grade is appropriate for these children and should be kind of at the same par as the regular classroom. What they're saying is, you're a general education student first. You're a general education student. We expect you to learn. We expect you to progress. No two children learn alike, but we expect those supplementary aids and services to help the student progress. So what is special education? It's specially designed instruction to address the unique needs of the student that result from the disability and to ensure access, not success, but access to general education curriculum. So you can have a disability and not qualify for special education if it doesn't have an impact on your ability to learn in the general ed classroom. So there's got to be one area, someplace that you need specially designed instruction. That might be in academics, and it might be in your functional performance. And it means individually adapting to the content, methodology, or delivery of instruction. So you have a kid with dyslexia, they might need adapting the reading program to ensure that it really addresses the needs of the child because of dyslexia. And that methodology needs to change. You want to address the unique needs of the student and ensure access to that general education curriculum. That is so important, and that's through the law several times. Just because you have an IEP doesn't mean that you are in a room with the door closed, working on your own curriculum all by yourself. For some extreme, those very unique children, it might be that, but generally no. It's the place you start is the classroom you would attend if you did not have a disability, adding supplementary aids and services to that setting. And that's what they're talking about. That specially designed instruction needs to reflect the general education curriculum because they're general education students first. And what are related services? It means those developmental and corrective services to assist the child to benefit from their specialized instruction. Speech therapy, occupational therapy, physical therapy, working with a psychologist, working with a social worker, having adapted curriculum, having assistive technology to help you, enlarge the words on the computer so that visually you can see them, things like that. What is FAPE? We're going to start with the general ed curriculum. Once again, that's the core to all of our school. All of our learning is that general ed curriculum. We're going to wrap around special education supports for the general ed curriculum. I'm having a really hard time reading. I'm not going to access my curriculum if I can't read it because I'm in high school. But, what are we going to do? Well, we're going to give you special education for helping you learn how to read with your disability, but we're also going to give you some supports with technology so that you're getting the content even though you can't read the content. And those related services are assistive technology and things like that to help you access all back to the general ed curriculum. So individualized IEPs, the IEP, the I in the IEP is the individual. We always need to remember that based on your unique needs. The present levels of academic achievement and functional performance, or PLAAFP, that's your starting point. So we're going to compare to the general ed curriculum. What's the blocks? Where are we starting? And what are those blocks that we're encountering that's making that block to accessing the general ed curriculum? What skills do we need to work on? Where are we looking for this student working on these skills? And compared to the standards of the curriculum and the standards of the grade, where are we? You're, reading at 4th grade level and you're in 8th grade. So what are we going to work on? And what's going to be the most important thing that we work on to get us through this process? So we're going to have an IEP goal. The IEP goals have to be measured, but you measure them from this first one, the present levels of academic achievement and functional performance. That's your starting point. You're looking at what skills do we need, then we're going to write the goals. And it's going to be unique for every student. We don't have a bank of reading goals. We don't have a bank of writing goals. We just have the students' needs. That's where we're going to get them. There are, on the website, there are different examples of goals. You may cut and paste, but only if it fits the unique need of the student. We always want to consider the 3 maximums in least restrictive environment. To the maximum extent appropriate, children with disabilities are educated with children who are non-disabled. Your starting point is the classroom the child would attend if that child did not have a disability. To the maximum appropriate, children with disabilities are able to participate in extracurricular activities with children who are not disabled. Once again, you're a general education student first. If you want to try out for drama club, you get to try out for drama club. If you want to try out for basketball, you get to try out for basketball. You get to be a general education student first. And to the maximum extent appropriate, children with disabilities are provided supplementary aids and services to enable them to be educated with children who are not disabled. That goes back to that means, once again, children are general education students first. We're more alike than different. And these words have been in the law since the beginning of the law. when the law started, it was like, we don't have special education. What are we going to do? You know, we don't do this. And they made special education classrooms and put all the kids with disabilities in there without regard to this part, because they just didn't know how to do it. We've grown, we've learned, and now we can do it. Pam, do you want to take like a 5-minute break or something? Does anybody need a break? Okay, so let's go on. So we have the 3 maximums that are really important for us all to remember, that the student is a general education student first, with the support of special education services and related services. And how do we get to that FAPE continuum? Well, we start once again with that evaluation and the evaluation process, because we've got to have a starting point. And your starting point needs to be a reliable one, so that we know, and that's when we look at what is the block to education. Then we go to present levels and need. So we're at a 4th grade reading level, but we're in the 8th grade. And so we can see that we need to kind of move up, but it is comprehension. It's the ability to decode words. You know, what's going on right here? Where's that need? And based on that need, we can make a goal that's going to be something that we can measure based off our evaluations. And we're going to measure that goal to make sure that we are making progress and that we're guessing and we're providing services that we actually need. Those services are to the maximum extent that we can be provided for that student in the least restrictive environment to receive educational benefit. That's the purpose of this whole process. So the function of the IEP team. So the student's IEP team must be developed by properly constituted IEP must be developed by a properly constituted IEP team. In the law, the first party listed in the law are the parents of the child, and that's the role that you're going to assume at this point. Not less than 1 regular education teacher of the child. That's if the child may be participating in or is participating in general education, regular education. So if you're, if you're in 1st grade, the 1st grade teacher gets to come. If you're in high school, they're going to have a team member to represent the team. If you're having a big struggle in math, but the English teacher is the one who is designated to, be the team member for the IEP team, you can ask that be changed, because you want the person there who is, the teacher that is going to help you overcome the block to learning. And if it's like English, then you would prefer to have the English teacher there, and you can ask for that person to attend and take the place of the math teacher who normally attends these meetings. Because in high school, it has to be a regular education teacher. High schoolers, middle schoolers have many. They have several teachers. So a lot of times schools will choose one to be the IEP representative for a student. So, but you can have input on who that person is. In elementary school, the teacher is the math teacher, the literature teacher, the social studies teacher. Elementary, teachers pretty much do it all. So, but once you hit middle school and high school, it's a little different. You have to be a little more deliberate in who that person's going to be. Not less than 1 special education teacher of the child, or not less than 1 special education provider of the child. And sometimes the little guys, preschoolers, the preschool teacher is the special ed teacher, or the provider is the speech language therapist, because that's what the disability is, speech language. But the child doesn't need special education services, just speech language services. And a representative of the public agency, that means somebody who represents the school district, who can write the check. If we need an expenditure of money, somebody needs to be there who can say, yeah, we can afford that service, or we can provide that service for you. And then someone who can interpret the evaluation results. Speech therapists cannot interpret a psychological report. A psychologist cannot interpret a speech language report. So it has to be somebody who understands that evaluation and who can interpret those results. For the mandatory team members, we listed 5: parent, special ed teacher, regular ed teacher, administrator, and interpreter of results, but we only have 4 chairs. In a normal IEP process, parents, school districts cannot require parents to be there. In this one, there's a 5th chair. Parents are required to be there, and that's you if you take on this job. All the chairs must be full for the entire meeting. One person may fill more than 1 chair, so the school psychologist might be acting with the authority of the district representative. Or in preschool, the special ed teacher and the general ed teacher are 1 person, but only for preschool. In our state, we try to make it more even, I guess you could say, and have it, but parents, school districts cannot require parents to attend IEP meetings. In this case, you are required to attend it. That's the whole purpose. And then parents are equal participants in this whole process. Just, remember that that's why you're here, to ensure that this student who has experienced trauma somehow and has ended up with an ESP, we really need to be looking out for their best interest and what's available to them. And parents are team members. We have an equal say in this. We're the protectors of the student's rights under IDEA. And the school has a legal obligation to propose an IEP that provides that free, appropriate public education. And parents have a right to object to the school's proposal. So if it doesn't make sense to you, or think it's not enough or not appropriate, it's your obligation to speak up. And predetermination, that's when the school district looks at a student without input from the parent and says, yep, that child's going to go to, the special ed classroom because the behaviors are too been demonstrated or reported as being, really bad. So that student's just going to stay in the emotionally disturbed classroom for the whole day. That's it. That's predetermination without parent input. Parents have a right to have that meaningful input. And, he can't go to, geography or science class. What would he get out of it? He's not going to understand anything. So, let's not put him in science. Kid might really like science. And how do you know? He has a right to that exposure. He has a right to experience science with the use of supplementary aids and services. So the process, once again, has a pattern to it or a structure to it. It's that referral. Referral can be from parents, but in this case, it's probably going to be from, someone else, someone within the school district or someone within social services is going to refer this child to an evaluation. upon that referral, that's when they would request an educational surrogate parent to sign the permission form for the evaluation. And then after the evaluation, that's when you determine, does this child have a disability? And the significance of this disability has an impact on their ability to learn in general education without support. Then if the answer is yes, then you develop the IEP and you participate in that process. And that's why it's important that you get to know the student and you get to get a feeling of what they like, what are their interests, what are their strengths, interview their teachers, talk with staff. You have that right to do that, and be a participant in that process of developing the IEP. Then you get to check up on them. You get to follow the implementation and the provision of service. So if they say this child needs, speech therapy 3 times a week, you can say, I'd like to see I think we need to have a sign in, sign out sheet for the therapist so that I can have a record of if that provision of service is being followed. And you can ask for that. You get to review and then sign for reevaluations or determine if reevaluations are needed. So it is a process, and this process is a continuous process. You have your evaluation and eligibility. Every year, you're going to look at developing the IEP, not from scratch a lot of times, but moving forward on this program. Then making sure that what's written in the IEP is actually implemented at school. And that's that progress monitoring. Every time the student receives a report card, you should get a report card on the progress towards the IEP goals. That's progress monitoring. It's not just a report card, but it's also a separate report on how the student is progressing towards the IEP goal. Then you have an Iep review and revision. Every school district is required every 365 days to provide that. You can have a review Iep meeting anytime you feel it's necessary. So you might think, I don't think we're really making a lot of progress here. Let's see what's going on. I'd like to have a review Iep meeting. And it might lead back to more evaluations. And so the circle continues. So evaluation and eligibility, the child find referral, every district has an obligation to locate and refer children suspected of having a disability, to evaluate them free, to see if they would be eligible for special education services. So that's called the child find mandate, and it's birth to 21 years old. Birth to 5, they have a child find coordinator who is, for the younger children who might not be in school yet. Once you're in school, then it is the IEP evaluation process. So the process begins with that comprehensive evaluation. When a child is in social services care or human services care, once they enter that system, they qualify for Medicaid. And under that mandate, Medicaid has 30 days to give a complete evaluation of the child. But that's a physical evaluation. And that the school might at that point want to have an educational evaluation of the child. You want to look at the complete child. You want to look at the whole child. It might be something you just ask a question and then move on, or it might be something that you say, I think we need to have a more in-depth evaluation. Marianne Fleury, who is in charge at CDE, she was a special ed director at one point, and they had this child they really thought had a learning disability, and they wanted her to come to the IEP meeting, and she did. And because this child was having a very difficult time following schoolwork and learning to read, and had moved into the district that year, but was not making progress in academics and reading. But it seemed like got information if you talk to this child about the information. So she was saying, let's look at everything here. Has the child had a vision screening? And the staff said, no, we didn't have a vision screening because she came after the vision screening took place. She said, then we really need to have a vision screening because we need to look at the complete child. The child needed glasses. And once the child had glasses, she no longer had a learning disability because now she could learn how to read because she needed glasses. That's why it's important that we not assume, but we take a look to make sure that we're checking all the boxes here. We're looking at their health and vision. We're looking at their cognitive abilities, their academic skills, their communication skills, their social emotional skills, your functional performance, your functional skills, and your physical and motor skills. We are complex people. Our students are complex people. We need to have a mechanism of making sure that we don't skip any boxes. And the IEP, when we start to write the IEP, it is a written plan for each student eligible for special education to meet the unique needs of the student. And it's based on the data that we've collected. And sometimes you're going to have kids who come into a system who you don't have a lot of data on them right at the beginning, but you've got to make a good guess and you got to move forward in a way that you're trying. I say, when you're writing IEP goals, you're taking your crystal ball and you're looking into the future and you're going, I hope we can, I hope we're making good educational guesses here for this student. But you've got to start someplace. And then you can review and reflect on it and change it if you need to. So there are 3 types of IEPs. We have the initial IEP, which is the very first one. That's when parent signature is needed. You have to have a parent signature for all special education evaluations. The parents must agree in writing to those. But to have, once you look at the results and say, yep, we need to have, this child needs to have an IEP, an individualized education program, then the parents must sign, giving permission for the school district to go forward with the IEP process. You're not signing that you agree to the services. You're signing that they can develop an IEP and implement an IEP, but we don't know what that looks like yet. Then you have an annual IEP. Once you sign the first IEP, if that student is still in the district and you're still acting as the educational surrogate parent, you do not have to give permission for an annual IEP. It happens. And the reevaluation IEP, which happens every 3 years. Once again, unless there are evaluations taking place, your signature is not needed. Your signature is needed for special education evaluations at any time, and your signature is needed for the initial IEP so that the IEP process can start. So once again, the basic steps of this whole IEP process is eligibility, evaluation, your present levels of academic performance and academic achievement and functional performance. And once again, that slide needs to be fixed, Pam, every time I see it. Identification of needs and annual measurable goals and short-term objectives. You only have short-term objectives if the student is working on a very unique curriculum, totally designed for that student. So a student who is functioning at a pretty low cognitive level, you could have short-term objectives. Plan for the delivery of services and supports and services. Who's going to do what, when, and where. So who's going to provide that service? What's that service going to look like? How's that student going to be supported in the general ed classroom? That's a really important part of the actual functioning, the actual work of the people who are going to support this student. And then placement in LRE, how close are we going to get there? Once again, classroom you would attend if you did not have a disability, adding supplementary aids and services to that setting. And you move away from that setting when supplementary aids and services are not successful in that setting. So, but you always begin there. And then when is it going to start? Unless there's another issue, such as, we need to arrange for transportation, we need to buy a piece of equipment, it starts the next day. So it starts immediately unless otherwise stated within the IEP because of a reason for getting equipment or something like that. So the IEP, the present levels of performance, that once again, that's your starting point. It's like, where are we right now and where are we going forward? So you might have a child, children who are, gathered up and moved out of their home quickly into a new situation, a new setting. This is trauma. And once again, these students are not having an educational surrogate parent because their life is really rosy and good. So a lot of times kids, when they go through trauma, something is going to be delayed. Something is going to stop. Something is going to happen. And it could be behavior, little kids revert to bedwetting, that kind of thing. Emotionally, they kind of regress instead of progress. So we need to kind of take that into consideration too, but that should be in the data that's been gathered. And you have a right to talk with the social workers. You have the right to talk with, the foster parents or the caregivers of this, student that's been assigned to you. You have the right to talk to their teachers. And we really need to look at their strengths and interests, because we need a hook to hook them into school to make them feel secure and safe. And you want input from, maybe a parent if the parent's lost educational, custody at that point, but the guardian, and the ESP, all of that goes into this data collection. So it's important to carefully consider all the students' educational needs, and you might need to prioritize the needs that are most important. And those access skills are really important for, all students, but especially important for students who have gone through trauma. And that can include organizational skills, following directions, managing frustration and anxiety. I certainly would, discuss that, and looking at social skills, because there's going to be some kind of impact in that area. Then goals should be based on their, needs, but at the Colorado Department of Ed, and we like SMART goals. Be specific, be measurable. It's really important that we have a good we have a goal that we actually make sense to all of us. So, the student will be able to, increase reading, reading comprehension by 1.3 grades or something like that. Be specific about what you're looking for. How are we going to measure that? Be sure and ask, how does that measure out? With behavior goals, it's a little, more it can be a little more fluid or not as, succinct as you might like, but you need to talk about that. How are you going to measure that goal? Is it achievable? Can the student actually do it in 365 days? The IEPs are written for 365 days. That's going to include 2 school years. It's going to include second grade and third grade. It's going to include 8th grade and 9th grade. So keep that in mind when you're writing these goals and the age of the child and is it appropriate. You wouldn't ask a 5th grader to learn how to drive. That would not be appropriate. It would not be achievable and it would not be realistic. So, we want it to make sense for the student and the teacher in what they're learning right now. The time bound is 365 days. But for some goals, it might be a shorter timeline because you're really working on a behavior goal and you're looking at to see if something is really working. So you're going to give it a month and you're going to come back and revisit that goal. So your time can fluctuate, but the general timeline on an IEP is 365 days. Objectives are only required when the student is working towards an extended evidenced outcome. And that means that they're not doing the general classroom curriculum. They're doing their own curriculum at the time. Other than that, all the goals must be measurable for 1 year. Supports and services. This is a really important part because this is what we are doing. This is what the adults are doing. This is what the staff is doing to support the student. So we want to look at, what is that going to look like? Are we going to have accommodations for schoolwork for a student who finds it very difficult to read but understands content? When you tell it to them and they can certainly discuss it. So is their evaluation, is it going to look differently? Are you going to have it, instead of writing an essay, does this kid get a multiple choice instead? So you want to look at what are we doing to support this student? And it could include speech, OT, PT, those kind of services, or transportation if the student needs it. Other services might include a healthcare plan. A healthcare plan is when a student's on medication. So I have ADHD, I take medication at school. We have to have a health plan about where that medication is going to be stored and who's going to administer it and when is that going to happen. Or a student has diabetes, student has cancer, student has asthma. You need to look at those issues. If a student has medication or health concern, we really need to look at that to make sure that that's covered. Elementary students should never be in charge of medication. And so we really need to look at that. High school students, middle school students may not, they may not, it might not be safe for them to be in charge of their medications. So some of the drugs that, children with ADHD require can be pretty strong and have a street value sometimes. So we don't want them to have that responsibility for their medication. A student with diabetes may have to have on them like a candy bar or something when they're feeling, like something's coming on. A student with asthma may be required to carry an inhaler with them on their person. So you need to talk about that because it's going to vary, but healthcare plans, are important for many children who go to school. Communication plan generally means students with hearing loss or deafness. How are they going? Do they need an interpreter? Do they need FM system, assistive technology? What do they need to communicate, to talk with the teacher, to be able to understand the content coming in? So also a communication plan might be an important part of a student who is young or who uses sign language to communicate but can hear. And sometimes young students with speech issues, speech apraxia, or Down syndrome or something like that, actually use sign language as a way to communicate. And the writers of this law at the beginning, they were really thinking about children with hearing loss, but it can apply to other children too, who have a special way to communicate, and they need that to be reflected in the IEP so that they can participate in school. Vision plan for students who are experiencing vision loss or blindness. Do they need Braille? Do they need to learn how to transport themselves within the school building, who's going to help them get from class to class, who's going to help them, or how are they going to be able to read or receive that information. Behavior support plan for students whose behaviors are the impairment. One of the things that's impairing their ability to learn in school is their behavior. So either, angry outburst, or some children just get very anxious, and anxiety is so debilitating that they, throw up. And it's like, I want to be invisible. Don't look at me. I don't, don't yell at me. I'm going to throw up if you yell at me or speak harshly to me. So behavior support plan is not just for students who act out their behavior is disruptive, but students whose behavior internally debilitates them from participating in school. Then, does the student need special transportation services? Do you use a wheelchair? Are you really impulsive and you're 6 years old and you can't stand at the bus stop because you'll just run out into traffic? Sometimes, students need that special transportation services. Transportation services can be door to door, not just the bus stop, but a student who uses a wheelchair can be picked up at their front door and transported to the front door of the school. So is that a need that this student has? Then assistive technology, and assistive technology has changed. Our schools now, we have so much virtual learning. A lot of students, many students have laptops, Chromebooks, iPads, a way of learning at home as well as learning at school. And it's, great for a lot of students. And a downfall too is some districts don't do snow days anymore, which is really sad, but it is what it is. But you still have to talk about assistive technology. You might have a student who needs assistive technology and they say, well, we don't need to write it in there because all the kids have it. This student may need some apps that are different, that are needed to support the student in their learning. So part of it is, look at the unique needs of the student. Once again, you look at the unique needs of the child. So placement. After the students have been identified, you have your goals, you've determined the services, the Iep team decides what the appropriate placement is. Placement is not necessarily a place. It's the provision of those supplementary aids and services. It's provision of that specialized instruction to the student. So you have a student who has autism and is in the general classroom, but they might be in, the district might say, well, we want this student to be in second grade at, this other elementary school and not the elementary school that's closest to his home, because the other elementary school has autism specialists there. They have autism support folks there who really understand autism. So we want them to go to second grade at school B and not school A. Parents may say, well, it's close, school A is close to home, and, it'd be much handier if he went to school A than school B. Districts have the right to kind of put services congregated in a specific school. And as a team, you would work that out. Does he really need all that service or not? And, what would be the benefit of him going to school B instead of school A? And could some of those services come over to school A and not be at school B? So you may decide, well, we'll try it at school A, or you may say, yeah, I think it'd be really appropriate for him to be at school B. Doesn't mean he's going to be in a special room all day. What it means is that he will be in the least restrictive environment in second grade in school B. Then when he needs services, the services will come to him there. So it's a discussion that you need to have about, what's that going to look like? Services support access to general education curriculum as much as possible, because remember, they're a general education student first. You receive the support of special education and related services, but the place you start is the classroom you would attend if you did not have a disability, adding supports to that setting. High expectations are important. They're important for all kids, but they're especially important for these kids because you don't get to have an ESP because life is just rosy and good. Just remember that. And exposure to what our students are learning is really important. It's important for our foundation, that iceberg of knowledge that we're giving kids. And we only remove them from the classroom whenever necessary, because you got to consider what are they missing? What's going on in that classroom that is so unimportant that that student doesn't need it? So if you have a student who's getting reading support, he should be getting reading support during reading, not during math, not during social studies, not during art. He may really love art, and art is the hook that keeps him in school. Then we're keeping art, and they're going to provide services that they need to provide it one-on-one to him someplace else in another time and in another place. So when you're making that progress, that progress report's going to be sent to you, not to the child's home, or might be sent to the child's, caregiver, but to you. You are going to receive the progress reports, and you're going to receive the report cards. And those progress reports should be as often as the student gets a report card. Get a report card, you get a progress report. If progress is not evident, then you need to call another meeting and say, that's the whole purpose of the progress reports. If we're not making progress, it's that we meet to discuss it and change the IEP so that we can make progress. And please ask questions and seek clarification. Communication is so vital in teams, and this IEP team needs that really clear communication, because you don't get an ESP because life is rosy and good. So, and you may have to deal with disciplinary actions. So students with disabilities have an extra layer of protection. And when it comes to discipline, all of them do. And you have that 10-day rule, which is you can be suspended, not expelled. You can be suspended from school for 10 days total within the school year. So it may be 2 days in October, a day in December, 3 days in January. Whenever you hit that 10 days, that's the 10-day rule. And when you're suspended too, you need to have a manifestation determination. There's a process, manifestation determination meeting. That means, is the child's discipline, or is the child's event that happened the behavior, was the child's behavior a result of his disability? So if you have a student with ADHD and he's going, I think it'd be a really good idea, it'd be fun to light a fire in the trash can in the bathroom. Let's do that. That'll be fun. And then he gets in trouble for it. The principal says, why did you do that? Well, I don't know. It just looked like fun. Well, do you think, that was a good thing to? No, it's an awful thing to do. I'm so sorry. And the principal says, he knows right from wrong. I talked to him. He knows right from wrong. It didn't have, he did it and he knew better. Say, well, he has ADHD. Did that play into it? And the principal may say, no, I talked to him. It didn't play into it. Well, part of ADHD is impulsivity and not thinking through to consequences. So I would argue, I think that the ADHD did influence his behavior. It was this behavior was a manifestation of his disability. So did the disability manifest itself with an action, basically? And then you discuss that and you come up with a plan. Your role as the educational surrogate parent is being the parent during this disciplinary process and asking those hard questions and seeing, what the answer is. So as the parent, educational parent, you have a right to look at the records. You have a right to ask for an independent educational evaluation if you think that the school's evaluation was not sufficient or not correct. You are to be given prior written notice and content of the prior written notice when you request something or when they request to do something. So it needs to be in writing and you get the copy of it. You can request electronic mail concerning this student. You can request mediation. You can request, you can do a state complaint. If you said you were going to do speech therapy 3 times a week, it's been 3 months since you even had one. Well, the speech therapist quit. We couldn't find another one. Well, you owe that student that service. So it could be a state complaint that you could file, and the state would come back and say, you need to do compensatory service for this student. And then they have to make it up. Due process and civil actions are all in your rights as acting as educational surrogate parent. And then transfer of parental rights at the age of 21. Here, because special education services end at age 21 if the student has not graduated with a general education diploma. And some students who have really significant disabilities and cannot cognitively take care of themselves and are going to be in adult systems, that would happen, and you would be done, and then another agency would take over. However, you have students who are in transition from 18 to 21, you might be involved. You have students who with disabilities who graduate at 18, then they no longer need an educational surrogate parent. So when you have different agencies kind of working together around a student's need, then ask a lot of questions. And then you have the right to be involved in those disciplinary procedures. So if a student is, suspended 10 days during a school year, or has a really strong incident, they bring a gun to school, they bring a knife to school or some drugs to school or something like that, the principal can say, this student is no longer welcome to be educated in this building. And you need to find an interim alternative educational placement. that's a whole nother road. And, but the student is still an IEP. Students with, IEPs and especially emotional, disabilities, schools can't just say, you're expelled, the end. They can't. They have to provide education for them in accordance with the Individuals with Disabilities Education Act. But principals do have the right to say, this student is unsafe, he's a danger to himself or others, and no, we're not going to educate him at this building. You got it. Then the district has to find another placement for him. So, what if the meeting isn't going well? Then when more assistance is needing, you can ask for an IEP facilitation by an impartial facilitator, and it's working pretty well. Colorado has decided to add alternative to dispute resolution, and that is this facilitated IEP process. And the purpose of the facilitation is to really help the IEP teams work and work well together. So it really helps to maintain that open communication among all members, teaching and using active listening skills. They help the IEP team develop and clarifying questions so that all members of the IEP team are on the same page and looking at the same information in understanding how other people are interpreting that information. Sometimes we get caught up, or teams get caught up in that lingo. You're talking education lingo and they go through it and they're all working together during the day with the parent on the outside. And then the parent comes in and says, I don't know what you're talking about, and I don't agree, and it's trust us, we know what's best, and and now we're moving on because we don't have a lot of time. And parents and other team members too, but feel left out of the conversation or left out of the team. A facilitator is trained to kind of spot that and stop that. So the purpose is to make sure that everybody has consensus before they move to the next step. So we're going to determine a student, has a disability, instead of just, yep, has a disability, let's move on. It's like, wait a minute, do you agree with that? What does that look like to you? And they ask questions so that everyone has a chance to really contribute, but also really understand what the other people are saying too. And they also help, we have a timeline, we're going to move forward, but we're going to make sure that we're going step by step with consensus and understanding the resistance and resolving those conflicts as they come up through this, process. So it is managing a conversation, but making sure that people are understanding each other before we move forward. All the team members want the student to succeed. All of them do, but we all have different perspectives. We're all looking at them in a different direction. So when we can come together and see what the other person sees, it's helpful. Facilitation is not an advocate for one side or the other. The facilitators are impartial, but they know the process and they've been trained in active, this communication facilitation. Actually, they should call it communication facilitation as well as anything else. And they are not a mediator or confidential mediated agreements. We're not coming up. They are to facilitate the IEP process. It's not mediation, and it's not due process, and it's not saying you win, you lose. It is conducting that conversation, making sure everybody is understanding what the other person's trying to say without hurt feelings because they're neutral, and helping people to listen and hear what the other people or person is really trying to express. So if you want to, and you can ask for a facilitated IEP if you want, and it's a good process for ESP would be perfect for asking for a facilitator because you're all new to this person who you're helping to facilitate the IEP for. So you ask the at the Colorado Department of Education, and there's a website and there's a form that you can fill out online if you want to. Marianne Fleury's in charge of this part of, she's in charge of facilitated IEPs also. You get an agreement from both parties, from the school district and the parent. Both have to agree because this is a voluntary process. So if both parties agree to it, then you sign an agreement and a facilitator is assigned to your IEP process. And the facilitator contacts the district and parents at the same time and to agree upon an agenda for the meeting and before the meeting, and then they come together and it's all signed. Then the facilitator begins with introductions and the agenda, the agreed upon agenda that can be revised at that time. And then after the meeting, there's an evaluation process. But it's nice to have that neutral person there who's really kind of listening to both parties and being able to help ask clarifying questions or to stop and say, no, this really needs to be answered before we move on. Or can you live with this? Can you live with this for a month? Can you live with it for a year? And helping the team kind of work together and learn how to work together with each other. Under the dispute resolution options, you have mediation. Mediation is voluntary, and both parties agree to mediators. Neutral mediators assigned. Mediators in our state are generally administrative law judges who are working in as mediators. They might be, and who are also trained as mediators, actually. And a mediation is that conducting the conversation once again, but more in depth. Then you can come up with a mediated agreement, which is binding if both parties agree to it, but you have 3 days to change your mind after the meeting, and you could withdraw your signature. But it's a mediated agreement, and it's not an IEP process. It's not in the IEP. So if you have something that needs to be put in the IEP, you need to have an IEP meeting to put that mediated agreement in there. So it could be, you can have mediation over the, people aren't treating me with respect and I feel really left out and we can't go anywhere because, my feelings, I feel like you really don't value us. So it can be a feelings kind of thing. It can be an interaction with people kind of thing. And you work through that. And I was with one person who in a mediation, and we're walking into the building for the mediation, and she's going, I hate them, I hate them, I hate them. They lie, they lie, they lie. As she's walking up the steps, I'm thinking, well, this is a waste of time. And they came to a mediated agreement in one day that lasted 4 years. And it was because she did not feel heard and valued, but she liked one person in that whole school system. And that one person agreed to be her contact. And it worked out well for 4 years. So mediation can work. Due process complaint, this is law-based. This is, what does the IDEA say? What's happened? What didn't happen? And I, as a judge, I'm going to make a finding and a decision for you. And it's, you give testimony, you swear that you're going to tell the truth, and you answer the questions in a black and white manner. So it's based on the law, due process complaints. Lawyers, school districts will have a lawyer. Parents don't have to have a lawyer. You can act as your own lawyer, but just know the school districts will have an attorney there. State complaint is a written process, and you can, you send in a written complaint about what has not happened or what, the whole event. And generally it's about, the school district agreed to this IEP, they were going to provide services, and those services have not been provided. Those services are not provided in the way that I was told they were going to be provided. So that's a state complaint. And then a complaints officer will receive the written document. They will review it, and then they'll contact the school, and they may contact you, they will contact you within 5 days to say, yes, we've received your complaint and we're going to investigate, or we've received your complaint, but based on what you've stated in your complaint, we are not going to investigate because it wasn't under our jurisdiction to make a ruling on that. So they'll contact you though, and then they'll do the investigation, they interview both parties, and then they render a decision. The school district has to provide compensatory services for a student, or no compensatory services are needed because they really weren't out of compliance. Whatever the findings are, they will give it to you in a written form. But the two parties do not meet face to face. So the summary of the procedural safeguards, and I would recommend that you, or we can email it to you too if you want, that you put it on your computer and you look at it and read it. You have the right to written notice. That's that prior written notice. If you request something in writing, they have to respond to you in writing. Yes, we will, or no, we won't do that, and here's why. You have the right to participate in the whole IEP process as a parent, and you have to give consent to conduct evaluations for the initial placement into special education. So that's that. When your signature is really required, is to conduct evaluations, and for, yes, we're going to develop an IEP, and you are allowed to provide special education services for this student. I don't know what they are because we haven't written it yet, but yeah, we're going to go forward with it. You have the right to ask for independent educational evaluations if you disagree with the school district's evaluations. And you have the right to, and the student has the right to, that confidentiality. But in this case, it also means that you are going to respect the confidentiality of the student and not discuss it with people who don't have a need to know or need to have it discussed with them. You have the right to a facilitated IEP, ask for a facilitated IEP. You have the right to ask for mediation, state complaint, or due process if it comes to that. And because you are a volunteer and appointed by the special ed director, if you have been faithful in your commitment to the student and you have been trustworthy with confidentiality and all of that, he cannot or she cannot request that you resign your assignment because of state complaint or due process. And now we have time for questions, and we'll end early today.
Great, thank you, Shirley. I'm going to take us off. I'm going to stop recording now.